So what was your first impression when you read this motion?
I was a little downhearted.
Really?
Um, I really feel like, I mean, my personal opinion right now is that I wish the defense did a little bit more research in what they were doing, opposed to they just kept filing motions and filing motions. And, it is what it is. There's not much we can do about that. But I just, the way they broke it down as to the reasons why the motion did not go through, the bond is not going to happen. I really feel like the defense should have known that this was going to take place. If it's based on the charges that he has, that's not letting him out. I think they were in hopes of that the COVID-19 was going to be a reason to have him come out. So Chicago is now saying that the COVID-19 rate in the prisons in the MCC has went down. So a lot of people that had tested positive before, they're trying to say that they had recovered. I think it was like 90 people. Now it's down to like 49 people. So they're trying to say only 49 people had the COVID-19. The rest of them had cured from it. So with that being said, that brings us back to square one.
Right.
Use the COVID-19 no longer as an excuse to get him a bond.
Right. So honestly, like I made comments before in some of my other videos on why he should have changed up his strategy, and it was the one time you had Spit and Fire on your show, and
Yes.
Spit and Fire didn't agree with me. And nothing against Spit and Fire. I love all YouTubers equally the same, but after reading this motion, because we had that conversation, I don't know if you remember that video, and I presented a strategy which I thought could have gotten him out of jail, at least temporarily on bond. But Spit and Fire didn't like it. I forget exactly what she said, and nobody really seemed to. I think who else was on there that night?
It was I think Dana J.
Mm-hmm.
Spit and Fire.
There was a few people that didn't like it.
Right.
Yeah.
Zoom, yes.
There was a few people who didn't like my theory, but now that I see this order, the final order on the bond, I can see that I was pretty much correct. And they said exactly what I thought they were going to say. Because I think one of the things, and I'm not going to talk too much. I'm going to try to read some of this actual order, right? So they basically say, raising most of the same argument pressed in his previous applications, the defendant continues to contest the court's finding, and presumably the same findings by other courts, that no condition or combination of conditions will reasonably assure his appearance as required and the safety of other persons in the community. And I actually have a video series about the bond for R. Kelly. And, if you guys want to check that out, you can probably check it out later, because that video series actually goes into detail about the statute that they're using in this judgment, which is 18 USC 3142. So I'm going to try to keep this down to a minimum. I don't really want to talk you guys heads off, and there's some delay with the screen. But, then they go on and they say, and the screen is delayed. Man, this screen delay is horrible. Where are we here? I'm trying to find the really good parts. Right. So one of the things I thought was interesting is they say the defendant bears a limited burden of production, not a burden of persuasion, to rebut that the presumption by coming forward with the evidence that he does not pose a danger to the community or the risk of flight, right? So it looks like they somehow shifted everything back on R. Kelly. Now it's actually kind of funny because it's almost the burden of proof, right?
Yes.
The burden of production and the burden of proof are similar concepts. The burden of proof is, I think, a little bit higher, but the burden of production is basically saying you have to come to us with some type of evidence that's going to prove that you're not going to be a danger to the community. You're not going to be a flight risk. And that's exactly what I was saying in the last time we went live, is that he has to go to them. He has to basically say, well, look, this is my plan. I'm going to stay in a halfway house. And I think you can get like witness protection program or something like that, where you're staying in under the protection of the government. I think it's the U.S. Marshals, and I think he should have combined that, even though it's probably never been unheard of. I mean, it's something that probably hasn't been heard of, but I think he should have enrolled in some type of program where he's outside the prison, but he's with the government agents, so
Right.
that he can basically prove to them that he's not going to run and he's not going to tamper with the witnesses. And then when he goes out into the streets or whatever, he could just pay to basically have a government agent, police or FBI agent, whatever you want, with him.
Exactly.
A lot of people thought that was crazy, but honestly, I think that's the only way that he could have gotten out, because he has to show the court that he's not going to tamper with the witness and he's not going to flee. And that's exactly what I said, and this is exactly what they're
Yes.
saying in their order or whatever. So, and the burden of persuasion, they're basically saying, don't persuade us, prove to us that you're not going to basically tamper with the witness, or that you're not going to run. And then they just basically go on, the presumption of favoring detention does not disappear entirely, but remains a factor to be considered among those weighed by the district court. The government retains the ultimate burden of persuasion, and by clear and convincing evidence that the defendant presents a danger to the community, by a lesser standard of preponderance of evidence that the defendant presents a risk of flight. So it's really funny what they've done here. But burden persuasion basically means that it's a really low standard.
Right.
It's an extremely low standard. So basically, with burden of production, you basically have to almost give them absolute proof that something is not going to happen. Right? It's an evidentiary type proceeding, at least from the reading I did. So you have to go in and you have to prove like 90 to 99% that this is what it is, or this is not going to happen. Whereas the burden of persuasion, you just have to prove above 50% of a chance that something is going to happen. So it's a really low standard, and basically they gave that to the government, and then they gave it to the government, I want to say, because of who R. Kelly is. Me personally, I think they're out to get them. I think they want to take them down. So
Yeah.
that's why they made it easy for the government to just say, hey, you just simply have to, slightly, and instead of saying burden of persuasion, I'm just going to say convince us, just
Right.
just convince us that he doesn't need to be out, in the streets or whatever. So it's an extremely low standard of proof or whatever.
Gotcha.
What else was good on here? Yeah, let me just go, because like I said, I don't want to read to you guys.
No, you're good. You're good. I'm glad you're explaining this, so we can understand it. For those of us who don't really get it, or whatever. I mean, it's pretty kind of self-explanatory, but there's certain things about it that kind of throws you through a loop. So I'm glad you're explaining this. Thank you.
Then they go on to say both indictments charge the defendant with serious crimes. They're talking about New York and Chicago. And this district, the indictment charges for almost 24 years. The defendant led an enterprise, the purpose of which were to promote the defendant's music, to recruit women and girls to engage in illegal sexual activity with the defendant, and produce child pornography. In the Northern District of Illinois, the defendant is charged with participating in long-running conspiracy to obstruct justice and to basically receive child pornography. Now, this piece to me just seems like it was just 100% nonsense. It's like, it's already, like, we kind of already went through this on both of our channels. Basically, the man was a musician.
Right.
There's tons of musicians out there who basically, and I think, who is that, the guy, Levi Ficelli? Levi Ficelli is a really sharp dude. I know we were talking about him earlier.
Yeah.
And like I said, I think Levi Ficelli is either a lawyer. I'm serious. I think he's either a lawyer.
Yeah.
You know what? I had three possibilities: a lawyer, a law professor, or he's somebody who basically had to defend himself on some type of criminal charge, and that's why he knows the law that well. But you know what? I'm even going to throw in a fourth possibility. It's possible that he just simply works in the legal field.
Right.
He could be like a clerk, or he could be like, someone that basically is around a lot of criminal trials or even civil trials, because he knows this stuff like the back of his hand. But honestly, I think he's more of a lawyer or a professor. And I think a lot of stuff that he was saying, because I watched the interview that he had with what's his name, the interview with
that grown man or something.
Yeah, the Grown Man Show, and he now has it. He changed the name of his station. I think it's Grown Little Boy or something like that.
Right.
But I think a lot of stuff that Levi Kelly was saying went over a lot of people's heads, and people don't realize how quick he was coming up with solid information that the average person just isn't going to have, right?
Right.
So I don't know. I just think this whole thing about the RICO and the conspiracy to defraud the United States is just kind of crazy. The RICO portion is really, in my opinion, is just a bunch of BS, right?
Yep, I believe that.
And when it comes down to the conspiracy to defraud the United States, after watching the debate between Levi Kelly and the Grown Man Show, I don't even know what to call the guy anymore. Grown Little Boy, Grown Man Show.
Right.
After actually watching that debate between them two, I actually think that R. Kelly can easily beat the charge for conspiracy against the United States. And I'm actually working on a video series on that right now, so I don't want to give up too much about that, but that video series should be coming out in the next couple of days. But essentially, it has a lot to do with double jeopardy, res judicata, and several other concepts. So double jeopardy, as everybody knows, is like one of the fundamental protections that we as citizens have from the government. And I think that Levi Kelly was trying to explain it, and I think he was doing a good job of explaining, but his explanation was just really on a high level. Right. I think he was trying to break it down and explain to the grown man, the guy on the Grown Man Show, why a lot of stuff they're doing in this, Illinois federal indictment is wrong. The conspiracy to defraud the United States is wrong. He was trying to explain it, but he was just constantly being interrupted, and the guy was interrupting him, and he wasn't really. And this is why I don't like debates. Yeah. Because he was too focused on debating with the guy that he wasn't really giving the guy a chance to speak. And then when he did speak, he wasn't absorbing the information. I think he was listening to him, but he was too focused on trying to, come back. Yeah, you're not even listening. You're not even absorbing what the man is trying to tell you. But anyway, yeah. At any rate, I think the conspiracy to defraud the United States is 100% going to fail. And like I said, I don't want to give out too much information right now because I am working on the series, but it has a lot to do with double jeopardy. So in my series, I'm going to get into why double jeopardy is going to be a huge issue with that. And personally, I think that if he beats that charge, because I think he's going to basically go to the feds in Chicago first, right?
Yes.
So personally, I think that if he beats that, it's going to make it much easier for him to basically prevail in this case. And on the flip side, if he loses, and I even hate to, start talking about him losing. I know that a lot of people love R. Kelly. I love him too. I support him. But, you really, in order to have a intelligent conversation, you have to, talk about everything, but unfortunately, if he loses, I think it becomes harder for him to basically win in the next case. And I'm going to explain why when we get to this, to a certain point in this motion.
Sure.
Then they go, what is more troubling from the defense perspective is that the court accepts the allegations regarding obstruction as a true evidence that he would obstruct now if released, but completely discounts the factual and historical evidence of appearance, right? And then it goes on to say, because an incident returned by a proper grand jury conclusively determines the extent of the probable cause. A court does not unfairly skew things against the defendant when it takes the charge into account, nor does it mean that the judge is simply accepting the government's position without critical analysis, as the defense argues. The other judges who have considered the question of bail, Honorable Harry D. Leinenweber, I hope I'm pronouncing his name right. Judge Leinenweber characterizes the charges against the defendant as extraordinarily serious and emphasizes the obstruction of justice charge. As far as the obstruction of justice charge, according to the specific counts in the indictment, that the acquittal was at least in some part obtained because of obstruction of justice, which involved allegedly paying off witnesses and threatening witnesses and buying back certain evidence in forms of the videos.
Got you.
And then she just keeps going on and just basically reading off what other judges have found. And I can't even pronounce this other judge's name. Judge Tissone likewise denied the bail. Judge Tissone observed that the defendant faced incredibly serious charges of sexual abuse of minors, coercion of minors, child pornography, and that the defendant has a history of similar allegations dating back far more than a decade. And then she basically says the judge was extremely troubled by issues of potentially obstruction in prior cases and the strong possibility that there could be a potential witness tampering in this case if he's released. So one of the things I noticed in those few paragraphs is that they're trying to stack the deck. And I don't even know if stacking the deck is the right word to use, but basically they're saying, well, this judge agrees with me and this other judge agrees with me. You know what I mean? So to me, it looks like they're trying to have a united front. So This is why I believe that if he loses a case in Chicago, I think they're going to try to use that as evidence, not necessarily as evidence, but they're going to try to use that as a precedent, right? So to me, it just looked like they're out to get him, right? You know, you never really want to say things like that. You want to believe that, you know, the system is fair.
Right.
But to me, it just looks like, you know, they're stacking the deck. I don't know.
I literally felt like crying when I read this earlier. Like, I can't believe how they are trying to pile this like the way they are. I mean, it's just, it's draining. It's sad, you know?
Yeah, exactly. To me, it looks like they're trying to pretty much treat him as if he's already guilty.
Exactly.
And then they're saying, well, you know, Keisha agrees with me, and not only does Keisha agree with me, but you know, Dana agrees with me, you know, so to me it just looks like they're just trying to have, you know, this united front. Exactly. So I mean, I don't know, does not look good.
Now in my chat I noticed that Dana had said actually the New York is first. New York is first.
Is New York first? Who? Dana's on it?
Yeah, he's in the chat and he just said that New York was first.
How is it that New York is first? I've always been under the impression that Chicago is first.
I thought it was too. I don't know. Oh, I don't have.
Why do you believe New York is first, Dana?
Dana, he's asking why. Well, I guess he can hear you.
Yeah.
I'm looking at my chat like I'm going to talk to my chat.
We should have got Dana, to join us.
I just texted him and asked him if he wanted to join because I know he knows this a little bit better than I do naturally.
Right. Now, basically, I did a video a while back, and basically it had the timelines for all the trials. And in that, I know that in that timeline, when the information first came out, Chicago was going to be one of the first trials that he would have, the federal charge. So I've always been under the impression that they were going to try to keep that timeline.
Exactly.
So if Dana has some different information, definitely come out and let us know.
Right.
Oh, we
Yeah.
even got Pico Benz in the house.
Okay. Yeah, you see him? Yeah. Yes, that's our buddy. Yep, my moderators. I got some great moderators. I love them.
I'm trying to get through some of the stuff.
Sure.
So basically, like I said, they are focused on two things. They're basically trying to say he's a danger to the community, and that there's a risk that he'll tamper with the witnesses. And I do want to apologize to everybody up front that, well, not an apology, because I don't really have to apologize to anybody, but I just kind of want to admit in a lot of my videos, I've actually had some pretty bad theories. It's probably why I'm not a lawyer. And one of the theories that, or one of the strategies that I was suggesting is that, you just go out and talk to these people and just say, why are you doing this stuff to me? And that actually would be
Right.
a horrible thing to do, because they're trying to nail him on this witness tampering. And you don't really know what could be witness tampering and what's not witness tampering,
Right.
um, so I kind of not regret, maybe that's not the best word to use, but I'm pretty sure there's a line of where you're considered witness tampering and when you're not considered witness tampering.
Right.
But either way, they're probably, if he talks to any of them, they're probably just going to say you're tampering with the witness. Uh, Without the confidence of security assured by a detention facility, United States versus Millen, the danger to the community cannot be eliminated, especially where, as here, the proposed measure are powerless to stop a defendant from including others to interfere with the witness. Yeah, so they're basically saying that, because in one of R. Kelly's motions, it seems like he said, hey, I'm going to, have home confinement, and I'm going to wear what do you call it, the little badge that you put on your leg when you're trying
Right.
to, he's basically saying he's going to do that, and they're just not with it. They're just not with it. So, I mean, I don't know. To me, it just seems like.
Oh, you know what? I got a call from Dana. I'm going to merge him in.
Merge him in. Merge him in.
Hello?
Hey.
Oh, good. You're on the speaker. That's what's
Hello?
up. Yep, we hear you. Can you hear me? You know you can't hear me all the time.
We hear you, Dana.
Hello?
We hear you. You might not
We hear you. Yeah, I'm just going to type in.
I can't hear nobody.
We're not talking. We're waiting for you to acknowledge us.
Can you hear me at all, Dana? Can you hear me? Can you hear me? Can you hear
I
me?
didn't say, can you hear me? But that's it. Then it
Yes,
goes,
we can hear you. We can hear you.
and then every time my lawyer talks, it's like real scratchy.
Can you click on the link? Can you do the Zoom link and we'll just bring you in the meeting?
Yeah.
All right. Okay. I got you. I'll do it right now.
Yeah. So basically, while you're doing that, I just want to, reiterate, because I think I chopped it up. Basically, R. Kelly was saying that he was going to do, home monitoring, and he was going to participate in home confinement and monitoring.
Right.
And basically they're saying they actually provided case law to say that's not enough to prove that you're not going to tamper with the witness. I just felt I had to re-say that because I kind of butchered it.
Right.
And then they go on and they just say it's well established that home detention and electronic monitoring may be insufficient to protect the community against dangerous individuals, particularly where those individuals have the ability to command others. So they're really they continue with this narrative of actually trying to portray him as a crime boss, which, I mean, I just don't see it. I just don't see how that works. Like, I guess if you don't know R. Kelly, like if you don't pay attention to R. Kelly, you could believe that. But anyone that kind of grew up listening to him and they halfway paid attention to him, they're not going to see Al Capone. You know what I mean?
Right.
They're not going to see John Gotti.
Exactly.
I think the people who are going to see that are the people who haven't really paid attention to his music. Like, yeah, they probably heard the name drop a couple of times, but they, don't know much about him because they don't really listen to his music. But I just don't see John Gotti. I don't see Al Capone.
Right.
I just don't see it.
At all. Me neither. Even when he was out, you didn't hear nothing about him trying to, do anything to the witnesses or the alleged Jane Does, and he wasn't worried about it. He wasn't. He was out walking his dog when they picked him up. I mean, what the hell?
Yeah, to me, it just seemed like he believed that he was going to prevail, just by going to court and basically, having his day in court.
Right.
And, they had other plans for him. So to me, like I said, and I think I've said it a lot in my videos, is that one of the things that I believe they're trying to do is that they're trying to get him to accept the plea deal. The longer he stays in jail, well, at least me, I can only talk about myself. If I was locked up, and I'm going to tell you, I'm a coward. I'm not even going to lie to you. If I was locked up and I could get out of jail, just by signing the deal and just saying I'm not going to do it anymore or whatever, even though I know that I didn't do it. And if I'm looking at maybe staying in jail for something like, 50 years versus just walking straight out,
Right.
I'm sorry to tell you, I'm not even going to lie to you. I'm going to sign a paper and walk out. Yeah. I mean, 9 times out of 10, I'm going to sign that paper and walk out. So I think that's what they're trying to do with him with this whole home confinement thing. Not home confinement, but, keeping him locked up. And I think the other thing, the other reason they're trying to keep him locked up, because they know if he gets out and he starts doing live sessions or he starts having press conferences and things of that nature, I think they know that he would probably persuade the general public that he's innocent, but the fact that he's locked up, he doesn't have a voice and he can't really speak, in my opinion. You know what I mean?
Right. I completely agree. He cannot do anything. I think he gets like one call a week because, of the COVID, but I think previously he could only call but like 1 or 2 times a week. They have it really tight in there. So you can't even call, to talk to the lawyers, and they don't want to go in there because of the disease. This COVID is wild.
Let me ask you a question. If he could do it all over again, and I'm talking about the period of time from which everything started up to the period of time where they detained him, do you think it would have been better for him to have regular? I think the Gayle King interview was just total nonsense.
I do too.
But, yeah, like I think that was a huge mistake. Yeah, I think he should have had press conference, but he should have, gone to Gayle King. Do you think it would have been a good idea for him to have regular press conferences, or do you think the better strategy was not to say anything?
I think that he should have I think he should have maybe had like press conferences opposed to being on a talk show like Gayle King.
Right.
You see how Gayle King expressed her emotions towards the Kobe Bryant situation. She really didn't care.
Right.
She was so eager to get the information out there that she didn't care whose feet she was stepping on, which was his family's, who just had a dad and husband deceased. So little cold-hearted there. And I think they just wanted him. I think they wanted him to explode in that way so they could go back to that video and like, look at how he exploded. Look how.
Well, honestly, there's nothing and this is what I'm talking about. I think if he acted like a perfect gentleman, they would have skewed it another way. Oh, he's crazy. Look at him. He's sitting there silent and he's not saying anything. There's nothing that he could have did that would have been perfect. Because one of the things I noticed after that interview, because they had the kind of like the discussion panel after the interview, and the CBS team basically reviewed the video. To me, it seems like they were trying to make up stuff. They were like, oh, didn't you feel uncomfortable? Did you think he was going to attack you?
Yeah.
I'm like, come on now. The dude was just, expressing himself.
Emotional. He was emotional. It's a lot. He's going up against a lot of people going up against him. And, now that I know what I know, I'm like, damn, no wonder why he was so emotional. Because it's like he's being stabbed in his back after he's done all these things for these people. None of them expressed to him, I'm positive, in his face that they were disgruntled or bitter or anything like that. I feel like they literally stabbed him in the back. He didn't expect this to happen in this way, and it ended up happening in this way.
Yeah. What happened to Dana? Is he still coming?
You know what? I sent him the link. I don't know if he's
Okay.
going to try to join in or not. I don't know where he's at with things. I know he just got off of his live. So
Okay.
I don't know if he's like.
Oh, he had a live. Okay.
Yeah. So.
Yeah, I mean, so there was, like I said, I don't want to read to you guys, but there was one other thing that I wanted to talk about. Let me see if I can actually find it.
Sure.
Oh, the other thing. Okay, so the defendant's diagnosis of prediabetes, a relatively common and treatable condition, is not a compelling reason for release. And then they provided some case law, United States versus Dutch. And that was the other thing that I think I brought up to Spit and Fire. And that's pretty much it. Whereas they were basically trying to, like you said earlier in the video, rely on, his health condition to justify getting him out of bail. And me personally, I think that was really the wrong way to go, because basically they don't care. They're really just trying to portray you as a monster, and you don't care what happens to a monster, do you?
Right.
So that's why I always thought that, mentioning his health wouldn't really help him. And I don't, like I said, I don't really think that he's done half the stuff they're trying to say he's done, but they're basically just trying to portray him as a monster. And because of that, they're going to say the risk of having him out, the risk, keeping him in outweighs the risk of him dying in prison. And that's the logic that they're going with. So I personally think that he probably would have had a much better chance of getting out if he had put a plan together and he went before them and he basically said that, I'm going to be under the supervisions of the U.S. Marshals. And when I leave that situation, I'll be accompanied by a marshal or FBI agent. And all the communications that I make will be made through the surveillance of, the U.S. Marshals or the FBI. I know that sounds crazy, and I know it's kind of like a restriction of his freedom, but in my opinion, it's better than being locked up in jail.
Right.
So
Right.
So I don't know. A lot of people disagree with me, but I think that was the best way. I think somebody said, why should he have to do all that to get out? He has to do that because they're trying to, hold him down.
They're not trying to release him at all.
At all. But if you do something like that, then it's like, in my opinion, they almost have to let you go.
Right.
Because you already read just above where they're saying monitoring and home detention is not enough to prove that you're not going to tamper with the witness.
Right. And that's what I feel like the motions that his defense team had put through were just specified. Well, I guess this was the only way to actually prove that he should come home is due to his health conditions, opposed to anything else. Like, they didn't file a motion because of this or that. They've tried previously to file motions for bond, and they all got denied, and that was before the COVID-19. So again, it just seems like they just want him in there. They don't want him to come home.
Yeah, and the most unfortunate thing about this final denial is that he can't really ask again.
Exactly.
So basically the way it works is that you can file a motion and then you get like 1 or 2 tries after that. I think you can file something called a motion. There's a lot of different type of motions that you can file to go back into court. One of them is called a motion to reconsider, and it depends on whether it's federal court or state court. But there's ways you can continuously go back and ask, but you get like 1 or 2 cards or 1 or 2 tries after your initial try.
Exactly.
After that, you can't really bring it back to the judge because there's a concept that blocks you called issue preclusion or something like that. I think it's collateral estoppel or something. What is it called? I don't know. I have to look it up. But basically, it's a legal doctrine that basically says it's already been decided on, and you can't keep bringing this thing back and forth, to the judge.
So one of my people just asked me. They said, "Is it too late to put that motion in yet?"
Which one?
There was a motion you were just talking about.
Yeah, and that's what I was saying. It's too late because this is like order here, right? And he's already, because he went to New York once, right?
He went to New York. I think everything's been done by video. From New York.
Well, let me rephrase it. So he asked them one time. They said no.
He said, yep, they've asked multiple times, yes.
Right. So then you file something called a motion to reconsider.
Yes.
Which is basically a mechanism to basically go back to the judge and basically either say, hey, you made a really bad mistake, or you can basically say that, you want to reconsider, maybe you didn't consider this evidence, so on and so forth. So I think the motion he did was a motion to reconsider. After they deny that, then you have to appeal. He can appeal this. He can actually appeal this.
Right.
So I think it's called an interlocutory appeal, which is basically saying that you're going to appeal this judgment while the case is still going forth.
Right.
That actually might be
possible. Yeah,
it might be possible, but here's a problem. When you appeal something, you can only appeal with the arguments you already made. It's very rare that you can introduce new arguments, right? So like all that stuff I said, I don't think he can put that in his appeal. He can only put in his appeal what they already argued about.
Right.
But you know what I mean? Like, you've heard this before, haven't you?
No, I understand exactly what you're saying. Like, it makes sense. It makes sense.
So long story dull, the appeal court is only, for the most part, they're only going to review what was argued. So if you didn't argue it, then how can they review it, right? They would probably say it's unfair. So I mean, there's some wiggle room with that, but I don't think he'd be able to put in new stuff. He can only go, and I don't know that it's worth the
keep on going. I agree.
Like
it's emotional.
If he didn't have all these cases going, it'd be worth it. But what if he goes to appeal this and he wins in New York, but then they still deny it in Chicago? You know what I mean? It's like you would have to appeal 4 times, and it's just not even worth the effort.
I think if they get this going in New York, then they can go against Chicago, and I think it might be easier in Chicago to get him released on bond than it is for this New York one. So I think that's why they're attacking it the way they're attacking it.
Right. Yeah, but if he gets released in Chicago, won't they just pick him up again?
That's it. That's why they're trying to get him out of New York. Like, look, give us a bond here in New York, and then we'll go to court in Chicago and look for a bond here and there. Start doing the motions to get a bond here and there. He's going to have 2 bond hearings is what they're looking for, I think. I'm assuming that's exactly how they want to do it.
Right. Well, actually, there would probably be 3 because I don't know what their plan was for Minnesota. I think maybe they figure if he won in Chicago and he won in New York, and then if Minnesota tried to execute a what do you call it? If they tried to pick him up, they would have a hearing in Chicago for extradition.
Right.
And maybe, and I'm not sure because, I've never really thought about this, but in Chicago, they probably could have made the argument, well, hey, they've released him on bond in the Chicago State Court. They released him on bond in Illinois Federal Court, and they released him on bond in, New York federal
Right.
court. So what would be the sense of him going to Minnesota? They probably could have made some argument.
Now the Minnesota case, I don't think he even went to a preliminary hearing for that yet.
Right. That's what I'm saying. So technically, if Chicago lets him out, New York lets him out, then Minnesota can basically arrest him, have him have the officers of Chicago arrest him
Now,
again,
now the
and then
Minnesota case would only be a bench warrant at this point for him not showing up to court. It wouldn't
shit.
be
A warrant is a warrant.
no, well, you got what is it? Bench warrant and then a regular warrant. So a regular
At the end of the day, they coming to get you.
No, a bench warrant, they can't just come pick you up. A bench
Are you
warrant
sure?
is positive. I've had one. So
What you have? Hold on a sec. All right, that's maybe that's a story for another time. But go ahead, break it down for me. What's the difference between
a bench warrant is just basically you missing a court hearing, whereas a warrant is like a bench warrant comes from like you missing like a district court hearing, just a magistrate.
I don't think. Go ahead.
Whereas I had missed a court hearing in a courthouse, in the county courthouse too.
For civil?
It wasn't my fault.
For civil?
No, criminal.
Oh wow.
So
you a gangster over there, huh?
No, not like
you the components.
They listed me as a notorious drug dealer. Anyways, so my lawyer had missed the court hearing. Like he didn't clock it in or something like that. I don't know how that happened, but we missed the court hearing. So I had to take my lawyer to the court, to the county courthouse for that bench warrant. I had to go to the what are they called? The police, not the police, sheriff. I had to go to the sheriff's department, do what I had to do there and all that. Oh, here's Dana. He's coming in now here at the end of the meeting. So I had to do that. I'm going to just admit him in here. So I had to go there. I had to go to the sheriff's department so they could, take the bench warrant out, whatever they do, void it there. I had to go through a whole process with that. Now, a bench warrant, though, is just simple. You go in the courthouse, you sign some documents. A warrant, you got to go to the county courthouse. A bench warrant, I only had to go to the district courthouse.
But let me ask you a question. So you're telling me,
preliminary hearing. Go ahead.
So let me tell you something. Let me ask you something. I'm sorry. You're telling me that if you had happened to go to Chicago for the weekend, you're telling me that if you got pulled over in Chicago, they wouldn't try to, arrest you?
No, because a bench warrant is just a district warrant. It's not a statewide warrant. It's not a county warrant either. It's just for that district. So if I'm driving in that district, they'll be like, "Oh, you got a bench warrant here. All right," and yeah, and that's when they can pick you up. So say you make a traffic violation.
But it's hard to believe that they wouldn't pick him up because they're hitting him. So does he have a civil case in Minnesota or a criminal case?
No. It's a criminal case. It's but the criminal case hasn't even went into a preliminary hearing. And the preliminary hearings are held at the district level and the magistrate level. Okay. So he hasn't even went to a district court. Once it gets resolved in the district court level, then they carry it over to the county level or the state level. So it's like he still has yet. What's up, Dana? What's going on? Listen, we talking about the Minnesota case, right? The Minnesota case, he hasn't went through the preliminary hearing, has he? No. Okay. So he still has yet to do that.
That case is put on hold.
Is it really?
Yeah, it's put on hold because state don't have precedent over federal.
Gotcha.
Right,
federal,
but it's put on hold, but in all likelihood,
that warrant was recanted about a week after she put it out there.
Really?
Yeah.
Okay.
There's no warrant for him in Minnesota.
So clear something up for me. Mm-hmm. So you're saying they're going to have the New York federal case before they have Chicago federal case?
Yes.
I don't believe that. Where did you get that information from?
I was just talking to Doug. But New York is September and Chicago is October.
Interesting.
Actually, I'm thinking, but the way they was going to do it was they was going to separate a month in between. But now, I think they're going to try to run them consecutively.
I don't know if a month would make a difference. Well, it would make a difference because you have more time to prepare. But running it consecutive, man, that's a devastating move because basically, if you lose in one, you don't get time to recuperate, recollect yourself. You know what I mean? It's like they're just
Right.
going to rush you to the other courtroom.
Now,
And
but here's the problem. They stacked him.
oh hell yeah, they stacked
And
them.
what I mean by stack is Chicago is doing something very illegal, not New York.
What you mean?
Well, well, in Chicago, federal supersedes state.
Right.
Well, the state judge said hell no.
They're still trying to proceed.
So basically, he's going to go to federal court in New York, and then when he gets to Chicago, hold on.
You're going in and out.
Hold on.
Sure, take your time. There you go.
In Chicago, he's going to have to go every day to court instead of every other day. Because
he's going to have to do both cases at the same time?
Yeah, because the state judge said he's going forward with it. And his case is, I believe, is the middle of October. And he had just finished in New York because for the New York case start September the 29th.
Wow.
So what they're going to do is they're going to run it consecutively. And then on top of that, by them running consecutively, he's pretty much going to be exhausted. That's
what I'm saying. Yeah, for sure.
This is going to be a beating. And it's like they trying to beat him into submission. Like today, everybody talking about, oh, this and this and this and this. I'm going to be honest with you. That rebuttal that she put, 100% bullshit.
You talking about in the order?
Yeah, 100% bullshit.
Yeah, I mean, basically, to me, it just looked like that they're trying to have a united front. I'm not going to say judges are coordinating because that would be unconstitutional for them to get on Twitter or or email each other and say, hey, we're going to do this. But to me, it just looked like they're trying to, put on a united front because they're saying, well, this judge said this, and, in this courtroom.
But I'm going to point something out to you real quick. Do you have the order in front of you?
Yeah, I believe I do.
But that order, for that part, when she said that she talked to both of the judges.
Oh, I don't know if she said she talked to him.
No.
She just, let me search once.
No, read that one section.
No, she didn't say she talked to him. She basically, I know what you're talking about. She referred to what the judges said.
But that's not what she said in that order. Really? What she said was myself, Lemonweather, and Tiscan.
Right, Tiscan.
All agreed and talked.
How did you pronounce that judge's name? Because I butchered that shit.
Man,
look,
I was. It took me like 3 hours. I was like, Jofaya. But I said, he said,
Judge T and shit.
But in that order, by the language being like that,
right?
And I was told today by a federal district judge in Georgia. He said, if R. Kelly lawyers really don't feel comfortable, they can always put in for a vindication change due to the fact that she's practicing from the bench.
Oh, here we go with that again. Now, me personally, Dana, I've been meaning to reach out to you. I've just been busy with work and everything.
Right. Y'all got a link. You, him, and Levi got a link.
Right, and I've been wanting to talk to you offline.
No, I got to talk to Dana first because we got to get through this.
I hear that
practicing from the bench thing because we got caught up on that the last time. I'm like, what is it? Because my whole thing with that is that I think that's something that came out of the free man movement.
No, I'm gonna be honest with you. Let me break that down. There's no such thing of a free man. There's no such thing of a sovereign citizen. There's no such thing of a citizen of a sovereign. There's only one thing. You're either a man or you're American national. One of the two. And the reason why I denounce
Man, we're gonna have some serious
oh yeah,
talk.
yeah.
Well, there is such a thing as a free and independent man.
Well, let me break it down. Free and independent
Yeah.
don't follow the constitutional rules. They follow the rules of the legal E system.
See, I don't want to hijack this session.
Oh, okay, yeah. Right.
But look, hey, Tasha, look, maybe next week.
My head, like, what the fuck they
Look,
doing?
hey, look, you know what? Look, we gonna
talk for about 4 hours, bro.
Yeah. Oh, and you know what? And that's another thing I'm trying to stop doing. I don't know how you guys do it. I'm not gonna be having no 2-3 hour video sessions. I'm sorry, y'all can have that.
Man,
Let you have it.
I got a battery pack in, man, and I'm always on go.
Wait, you know what? It's not that I don't have the energy to do it. I just got too many other things to do. I got stuff that's piling up. I got my video series I want to get to. This is too much stuff. But this is a really good topic. It's a really good topic. So, and it's a really good way to have a break from all this stuff. So
Right.
It looks like, if you're interested, Keisha,
Yeah.
we can have another session where we talk about practicing from the bench.
Yeah. We can take this over to Dana's channel or your channel,
Sure.
and I'll just sit there
sure.
and listen. I just want to
Well, you know what?
learn.
Well, you know what?
Sure.
I'm not well versed on how to do a live, and I don't want to,
Oh, we can do it on my channel.
we can do it at your channel. We're going to talk about. Just don't let me forget though, because a lot of
All
times
right.
these juicy topics come up, and then you forget about them.
Yup, I
Right.
get this one.
Right, but I'm gonna point something else out to you, non-lawyer. I told everybody, I said, if we ain't on our P's and Q's, they're going to turn this right in our face, under our nose, into a case law. If you read that motion,
Right. I read
how
it.
many times have they referred to the R. Kelly trial as a case law?
I didn't notice that, actually. I didn't notice
If
that.
you read it, I do believe they did it
Jesus
4 times.
Christ is right here.
Yup.
United States versus Kelly. That's interesting. How can you do that? How can you refer?
You can't.
Wow.
And see, and the problem is nobody is.
Hold on a second. You know what? It just dawned on me why you can't. The whole purpose of case law is you're quoting something that's already been decided by the Supreme Court or even the appellate court. So when they say United States versus Kelly, I'm gonna tell you what this is.
Wait. And before you do that, I'm gonna give you some homework. That United States versus Kelly is not the 2008-2002 trial. That's the trial.
Oh, Dana, you press mute. You press mute, Dana, by accident. Oh.
The only reason why they doing that, and the only reason why they doing that is because nobody's paying attention because we're all caught up on our emotions.
You know what? I'm gonna say this. I'm gonna say that it's probably more than what we think it is, because I can't see them trying to quote a trial that hasn't been decided on.
Oh my God.
So the
Watch
only,
this. But all you gotta do is look it up.
You see what he's talking about, Keisha?
Yeah, I hear what y'all saying. They trying to make a case out of something that ain't even
been decided on, right? But I guarantee you that's not what's happening here. There's probably another Kelly out there that they're referring to. That's got to be it.
No.
I mean, we can look it up, but I don't want to.
Look that 19-CR567. That'll tell you exactly.
Yeah, we can, but I don't want to go down.
No, that's cool. That's cool. Y'all can probably do that on your own time.
Right.
He's gonna look it up as soon as we hang up. Watch.
I don't think that they would be. No one would be foolish enough to do something like that, because at that point, you would be fired. You would be fired.
Oh my God!
There's no way they would do that. So they're talking about it. They got to be talking about another Kelly.
Well, watch this. I promise you tonight, after we get off, I'm gonna shoot you an email, and I'm gonna say, brother, take a look at this at your earliest.
Right.
And watch you be like, this little cross-eyed nigga from Baltimore. Why? I'm telling you, because it freaked me out today. And I said, yo, they using terminology that's not making sense.
Right.
So then I start Googling. I brought out the Google dictionary.
Wait a minute, you're right, because it still don't make sense, because what are the coincidence that there's another Kelly with a child pornography charge? It says, in the Northern District of Illinois, the defendant is charged with practicing in the long-running conspiracy to obstruct justice.
There is no other Kelly.
No, you know what? They're just referring to it. They're not.
But you can't even refer to an open case.
You can't?
Since when?
I mean, I don't know. I mean, I'm not going to. So I call myself the non-lawyer for a reason.
But I'm not the lawyer either. So I guess I'm the non-lawyer junior.
Right. I don't know that you can't do that.
There you go. You're good.
But I mean, you obviously see how they're basically trying to present a united front, and I believe what they're going to try to do is obvious. If they're doing this now, they're going to do it later.
Yum.
And that's where they're all basically presenting a united front. They're going to start referring to what another judge said and how another judge responded to a similar motion, and it's just going to be a united front. But I think if he can beat, now here's the thing, you came on kind of late. I think he can beat the conspiracy to defraud the United States charge. And it was basically based off some information that I got from Levi Kelly.
Well, I'm going to say this. All of the charges he got, he can beat. And I'm not going to say beat. He can be found not guilty.
Well, let me say this. Because I don't want people to take this the wrong way. You can be 100% innocent and still lose because you were outplayed.
Right. And somebody said something to me today that really, that really got to me, where they said that the jury can find you not guilty, but the judge can turn around and still find you guilty.
I've heard something like that.
And I said, huh?
I'm gonna have to look. I think I'm gonna have to research that. But I've heard that
in a jury trial.
Right. I'm gonna have to research that. Well, I know about jury nullification. Have you heard of that?
No.
Jury nullification is where the jury believes you're guilty, but they're going to let you walk anyway, and that's legal. It's 100% legal.
I got some homework to do.
Right. Now, I have a video. So if you go to my page, I got a video series where I talk about the R. Kelly jury selection. Mm-hmm. And it's in one of those videos where basically I explain, and it's a well-established doctrine, and it goes way back into the courts of England, right? And it's basically where a jury can basically, like, everyone has the responsibility to respect the law, but the jury can, in a sense, say that law don't matter. It's called jury nullification.
Wow.
Blew my mind. So that could happen in this case. Can happen in this case. The jury can literally come out and say, you know what? We believe he's guilty on all charges, but we don't believe that he should go to jail.
Wow.
They can literally do that.
Wow. But look, I got to get ready to run back to work. I'm glad I was able to jump in for a minute, man. And we need to hit each other up. Once you get off, send me an email again, and I'll definitely send you everything, and we're going to chop it up.
Yeah, no doubt. So I'm actually going to get off, too, because I'm going to go and get something to eat. But, Keisha, thank you for giving me this time to come on your platform.
No
and thank you, chat. See y'all, chat. Love y'all.
Make sure you guys are subscribed to Dana J, actor Dana J, and the non-lawyer. You guys got to make sure. It's 40 y'all in here. Make sure y'all subscribe.
No doubt. Please support the channel.
Absolutely. Absolutely. I appreciate you so much for being here tonight.
Oh, no doubt. No doubt. It's wonderful being there.
Thank you.
All right. Later.